Hey Erin, I was hoping I could interrupt you for a second. We're writing a blog article on a piece of case law, Rintelman versus Rintelman, and I don't really understand what it's saying, but it seems like the general premise is if parties agree to something and they want to change it later on, they might not be able to, and I want to just better understand it so that we're answering that question appropriately.
Yeah, so Rintelman v. Rintelman, I actually find this to be a very interesting case, and I have a case right now where we're dealing with this exact issue. But what happened here was that husband and wife agreed as part of their final divorce agreement that husband would pay wife maintenance, or alimony is another word for it here in Wisconsin. He would pay maintenance to her for her entire lifetime, even despite her remarriage. And the court at the final hearing had clarified with both parties that their agreement was that this payment would continue for their lifetime, and that if she was remarried, that this payment to her would not stop. Both parties acknowledged that that was their intent and understanding. So the issue that this case is dealing with is whether or not this agreement that the parties entered into is enforceable, despite the fact that if the court had made the decision on maintenance, they would have never given maintenance to wife for an indefinite period of time. It would have terminated upon her remarriage per Wisconsin law. So the reason this case is important in terms of history and procedure and precedent here is, the parties were divorced in 1979, went back to the circuit court in 1982 and filed a motion, and there wasn't really any law specific to this issue at the time, so it made its way up to the appellate court and then the Supreme Court. So this is now still good law here in Wisconsin that we use on quite a regular basis, and as I indicated before, I'm using this case in one of my divorce agreements right now. So what happened with the Rintelmans in this case is the Supreme Court upheld what the circuit court had originally decided, and that was that the Rintelmans had freedom of contract and that the court was going to uphold and enforce what their original agreement was, even if the court would not have otherwise ordered that at a contested or final hearing. So this case is important, especially to the case I'm dealing with now, because you can decide, or parties can decide, to enter into what's called a non-modifiable maintenance payment, either in length of time and amount, or either or. Specifically, the case that I'm dealing with right now, we are doing a non-modifiable maintenance provision on both, but I've also done cases in the past where we've just done a non-modifiable maintenance provision in terms of the time, so that the amount of maintenance can still be changed during that time frame, but the actual time frame of maintenance cannot be. And like I said before, the court would never order this. So this is why it's really important that you understand exactly what you're entering into, because you cannot go back to court like Mr. Rintelman did here and succeed on a motion to terminate maintenance after you have already agreed to a non-modifiable maintenance provision.
So it seems like, if I'm understanding this correctly, it's unbelievably critical for anybody to understand what type of contract they're signing into, because even if it's against what is in the statutes, the court may not even entertain changing that agreement.
That is correct, yes. The court will enforce an agreement that you enter into, even if it is against or not in line with what the Wisconsin statutes indicate.
So how might that apply to, you mentioned earlier that you're currently using this precedent in a case that you're currently working through. So how is that being applied there?
Yeah, so I've had numerous discussions with my client about how important it is that if he wants to enter into a non-modifiable maintenance term and amount, that there's no going back after this, that he needs to understand the risks involved in that. So it's really, really important that you understand the terms of the contract that you are entering into.
Erin, thanks so much for answering this. Sorry for interrupting you. I know you're super busy, but I really do appreciate you creating clarity for this so we know how to address it online appropriately.
Anytime, it's my pleasure. Thank you for asking.
Case Law Friday is a Sterling series focused on communicating in layman's terms, cases of precedent, statutes that guide decisions, and court procedures important to getting results in family law. Please like and subscribe. We hope these deep dive conversations create clarity, enabling you to better understand the rules that govern how decisions get made in family court.